Good morning, everyone, and thank you very much for joining me this morning for the first in our series of bite-sized webinars for charities this year. The topic for today is charity mergers and collaborative working, and for the next 25 minutes or so, I'll be taking you through the topics that you see on the slide here. After that, there'll be a little bit of time for some questions, so please do feel free to pop your questions into the question box that you should see on your screen, and I will do my best to get through those at the end of the session. If I don't have time to answer your question, or if you have something that's really specific to your own circumstances or a particular project that you're looking at, please do include in the survey that will be sent to you at the end of the webinar, if you would like us to get in touch with you about anything particular for your own circumstances. We'll then arrange for me or a member of my team to get in touch to see how we might be able to help you. Okay, so by way of introduction, when we talk about charity mergers and collaborative working, what we mean is the more formal sorts of arrangements that charities can enter into. Of course, there are absolutely loads of brilliant examples of collaborative working within the sector. Charities regularly share information, network with each other, and are members of umbrella bodies where there is an awful lot of know-how and resource available. But that's not what we're focusing on today. Today, we're talking about specific projects or initiatives where charities come together to work on a collaborative project, or at the more extreme end of the scale, a formal coming together of two charities in a more permanent way. Now, to be clear, when I'm talking about collaborative working, it's any kind of arrangement where the charities remain operationally and from a governance and control perspective independent of each other, but are coming together to collaborate. Now, that might be through the sharing of resources, administrative and back office functions, staff sharing arrangements, coming together for a fundraising initiative, a campaigning project, a profile raising project, or actually the delivery of services. Any of those sorts of arrangements, but still where the two charities remain operationally and from a governance and control perspective, independent of each other. When we talk about charity mergers, what we mean is a more formal coming together of the two charities in a permanent way, so that the operations and control of the delivery of whatever your charitable purposes are come together and are formalized in perpetuity thereafter. Now, whether you're looking at a charity merger or at a collaborative working arrangement, there are some preliminary key considerations that we would recommend you think about. These apply regardless of the structure, regardless of the project or the initiative that you're looking at. Now, first and foremost, as is the case whenever you're looking to do anything within a charity, you need to think about your own charity's purposes. What is your charity established to achieve? And will this project, initiative, merger, collaboration, whatever it is you're looking at, help you to advance and further those charitable purposes in a more effective way? If not, it's going to be quite difficult to justify entering into the collaboration. The second key thing to think about are whether or not you have the power to do what you're proposing, and also whether there might be other legal barriers that could stand in the way of the collaboration or merger that you're looking to achieve. So, for example, regulatory consents, key stakeholder, or other consents that you might require. These might be areas upon which you need some very early and preliminary professional advice if you don't have the in-house resource to be able to consider those points. There isn't a sort of general rule that a particular kind of arrangement is fine and others require consent or charity commission authority. It really comes down to what your governing documents say, what the nature of the arrangement is, and whether there are any particular restrictions affecting your assets. Once you've thought about those very early points, you also really need to think about the benefits and the risks of the proposal and carry out a sort of risk-benefit analysis. What is it that your charity is going to get out of this proposal? Now, that could be a reduction in costs or some financial advantage, or it could be enabling your charity to impact more successfully in the delivery of the charitable purposes, or perhaps reach a more diverse and broad group of beneficiaries. So the benefits could be financial, or they could be operational. They could be to do with impact and charitable impact of what you are trying to do. Once you've thought about those benefits, those risks, and making sure that the benefits outweigh the potential risks of whatever it is that you're looking at, the other key thing to think about is whether the ethos and values of your charity are matched with the ethos and values of the other charity or charities that you're looking to collaborate with. And this isn't something to be underestimated. It is important that you're able to work together in practice on whatever it is that you're looking to do. Depending on the nature of the project, operational compatibility can also be really important, more so for mergers and full coming together of charities in a permanent way than, say, for example, a time-limited fundraising project. But operational compatibility is another key preliminary consideration. It might be that the project is a great idea, but actually in practice you can't see it working because there are such big differences in the way that your two charities operate on the ground. Looking specifically at collaborative working now and the key considerations that affect this, as I said, we are not talking today about the more informal arrangements. So what I mean when I'm talking about collaborative working here is something involving a contractual arrangement, something more formal where you will have obligations and benefits from the arrangement that you're putting in place. So the first question is, well, why? What is the purpose? What's the goal? Why are we thinking about entering into this collaboration? And as I said, it doesn't have to necessarily be about financial advantage. It could be about impact or a combination of the two. How will it advance your charitable purposes and making sure that it will? Now, a key point to bear in mind here is you don't necessarily need to collaborate with a charity that has the same or very similar purposes to yours in order to advance your own charity's purposes. Provided that you are satisfied that whatever it is that the collaboration involves will advance your charity's purposes, then that's fine. What you can't do is support charitable purposes that are outside what your charity is established for. You clearly need to balance the risk and benefit, and I'll talk in a moment about some of the key legal considerations that will help to enable you to do that. And the other big thing to think about is a proportionate use of resources. What is it that you're being asked or you're expected to put in and contribute? And is that proportionate to the benefit that you will be getting back as an organisation? So the advantage in furthering your charitable purposes, the advantage to perhaps your beneficiaries, or the cost savings that you might be making. The final preliminary key consideration on collaborations is around commercial sensitivity. It's very common that if you're looking to enter into a collaboration, particularly on service delivery with another charity, that you're quite likely to be operating in the same commercial space. So you might actually consider each other to be competitors most of the time. Now, if that's the case, and you are likely to be bidding for the same contracts at other times, or you might have very sensitive know-how or intellectual property that you wouldn't want to disclose, you should think about those commercial sensitivities and make sure that you will be able to engage in the collaboration whilst protecting and safeguarding your charity's assets in the longer term. Unless you're talking about a very formal and permanent coming together of the charities, a time-limited collaboration, you still need to think about the protection and preservation of your charity's commercial sensitive information in the longer term. Looking at the structures that are available, and for some reason they are not, they are coming up very strangely on my slides here. I'm just going to pull those all up for you, apologies. So this is the full structure. So the first set there is at the top where there is a pure contract between charity A and charity B. So this would be where you've got two charities, and it could be more than two, but they come together with a particular project or initiative in mind, and you enter into a contract between yourselves, setting out what your respective obligations and benefits will be under that contractual arrangement. The other type of contract that you could find yourselves looking at is a supply chain. And this is quite common, where you get a contract awarding body that is looking to award a contract to a lead tenderer, but where in order to be successful in that bid, you need to have a number of other charities sitting behind you as actual deliverers of the service or whatever it is that you've been contracted to do. And commonly there you see a supply chain, so a main contract with the contract awarding body and the lead bidder, and then by sitting behind that a number of subcontracts between that lead bidder and all of the other charities that are participating in the delivery of that service. In that case, it's really critical, particularly if you are a lead bidder, to make sure that the risks and obligations are appropriately flowed through down that supply chain. The final main sort of structuring option that I want to mention today is a more corporate structure for a joint venture. So this might be where two or more charities come together with a particular project in mind, but rather than just entering into a contract to achieve it, they set up a special purpose vehicle, so a company in which they hold shares proportionate to their equity investment, their financial investment into that business. And then that joint venture carries out the project or initiative with either financial returns or impact returns flowing back to the parent charities. Now, there might be other structures, and of course, there are an infinite number of options as to how these might look, but those are, broadly speaking, the key formal structuring options that charities tend to look at for collaborative working. In terms of risk management, and these are the key legal considerations with any contractual arrangement for a collaboration, and don't be fooled by what it's called. If it's called a service level agreement or a memorandum of understanding, that doesn't necessarily mean that it isn't legally binding. It doesn't necessarily mean that you shouldn't think about these things. So whatever it's called, a contractual arrangement in which you are signing up to particular obligations, you need to think about these key risk management points. Now, the top point there is due diligence. Do you know enough about the other charity or charities that you are looking to collaborate with to get comfortable that this is appropriate for your organisation? And that's something that often gets overlooked. It's quite critical when it comes to thinking about obligations and making sure that those other organisations can meet their obligations and any liabilities that arise, particularly in a supply chain scenario where there might be joint and several liability as the collective for the obligations that you have to that contract awarding party. What you don't want is to end up being the last man standing in that scenario and finding yourself liable as a charity for the errors of another member of the group. So have you done your due diligence? Are you satisfied that these organisations are ones you want to get into a collaborative arrangement with? Not only can they meet their obligations, but can you meet yours? And are you comfortable that what is set out in the contract reflects your understanding of what you have agreed to do as part of this collaboration? Again, this is something in which professional advice is recommended if you don't have the in-house expertise, to ensure that the drafting of the obligations does in fact reflect your commercial understanding of what you have signed up to. Whilst this might seem counterintuitive, particularly at the outset when you're trying to enter into a collaboration, you do need to think about the termination points as well. How do you exit? When will this arrangement end and how? But also critically, what happens if something goes wrong? What happens if one of the other contracting parties to the collaboration fails, becomes insolvent, or is no longer able to meet its obligations for some other reason, or perhaps becomes subject to some scandal or some huge reputational issue, which means you no longer want to be associated with them and continue with the collaborative project that you've entered into in the first place. So thinking about those what-if scenarios is a really helpful way to make sure that the contractual terms clearly set out what happens and what your rights are if anything arises requiring you to, or making you want to, terminate and exit the arrangements. You also need to think about liabilities on exit and think ahead, particularly, for example, if you've got staff sharing arrangements or lots of staff who are dedicated to the delivery of a particular service. You should be thinking about any potential 2P consequences from a termination of a service contract and making sure that you've thought through where those liabilities would sit if any employment-related liabilities do arise. Now, this is again very broad brush because whether or not that's an issue will depend very much on the nature of the arrangement, but it's something you should be thinking about. Any liabilities that could arise on termination, who will be responsible for them and how they'll be handled. The other key thing, of course, is not just thinking about whether your obligations are appropriately reflected in the drafting, but also your rights. Is it clear and are you sure that the contract reflects what you think you're getting out of this? We have had examples, for instance, of charities that have entered into what they thought was a collaboration that would result in them receiving a certain proportion of grant funding, only to discover that actually what they've signed up for is that they will contribute funding for a particular project. So quite the opposite of what they thought was the benefit that they were going to get out of the arrangement. So be careful to make sure that the drafting does reflect your intentions. Also be clear about which provisions are legally binding and which aren't, and do not be fooled by something being called a memorandum of understanding. That does not necessarily mean it is not legally binding. What matters is the way in which the contract is drafted. So again, seek legal advice if you're unsure and you don't have the in-house expertise to look at that yourself. Final thought that may or may not be relevant, depending on the nature of the collaboration, is what happens to any know-how, intellectual property, or other assets that might be generated as a result of the joint venture or the collaboration. Who will own those? What are you going to do with those? And similarly, if you're contributing know-how or intellectual property or resource to the project, have you put in place appropriate provisions to ensure that your intellectual property is protected and remains yours and doesn't inadvertently transfer to any other party as part of the contractual arrangements? So those are some of the key legal pitfalls to consider. Now, what we will be doing later in the series of webinars is a bite-sized webinar specifically on managing risk in commercial contracts, where some of these points will be looked at in a little bit more detail by my colleague Edward Bouckley. So if you are interested in contractual issues in particular, I would encourage you to look out for that event invitation in due course. Now, collaborative arrangements are sometimes, not always, but sometimes a stepping stone to a full formal charity merger. But equally, sometimes a charity merger is on the cards from day dot, and you don't enter into any kind of collaborative arrangement as a stepping stone. What I'm going to do now is just talk you through some of the key structures and the process involved in charity mergers. So looking first at your asset transfer structures. So there are two key ways in which you can structure a merger. The first is through a transfer of assets, and the other is through a change of control. So broadly speaking, charity mergers can be structured so either one charity transfers all of its assets and operations into the other, so charity A to charity B, or vice versa. Or the other way is for you to set up a brand new charity and then tip all of the assets and operations into that new charitable structure. Now, we generally try to structure them when we're advising so that one charity tips into the other, even in a merger of equals, even when the two charities are coming together very much as a merger of equals and not as a takeover. And the reason for that is because it's more cost effective to do that. It is possible to structure that appropriately so that it is a merger of equals, but it just requires a bit of careful thought and management. The alternative of setting up a new charity is, as you can imagine, more time-consuming and costly because you've got to move all of the staff, assets, contracts, and operations of two charities rather than just one. In terms of change of control, the key structures for this are, again, either that one charity takes over the control of the other, so charity A becomes the controlling member, or the trustees of charity A become the trustees of charity B, or vice versa. Or another option that might be possible, and again, this very much depends on circumstances, is setting up a new parent charity that then takes over the control of the two existing charities. Now, as a word of caution, it is important that any new charity has its own charitable purposes. So this structure will only be achievable if that new charity will do something charitable. Being a mere shell to hold the control of other charities is not, in and of itself, a charitable activity and purpose. In terms of process, the starting point that we would always recommend is heads of terms. Now, this is generally speaking a document that is not legally binding, but is intended to make sure that you are on the same page in terms of what you are commercially looking to achieve. And my recommendation always, particularly in a merger of equals, is that you start off with this by thinking about your vision for the new merged charity. How do you want that new merged charity to operate? What is your vision for it? What do you want to achieve? And that is the best way to approach heads of term discussions. The kind of things to consider including in the heads of terms include what you envisage is likely to be the proposed structure based on a very high level review of assets and operations and which way you think it will be most appropriate, with professional advice, of course, as appropriate, to structure the merger. Now, this should always be made subject to due diligence because it is entirely possible that throughout the course of the legal and operational and financial due diligence, you might discover particular issues that change the view as to what the most appropriate structure for the merger will be. So I would set it out in heads of terms so that you're on the same page, but keep an open mind to any particular issues that might arise during the more detailed due diligence process. You should also think about any key consents that the merger might be subject to and just consider those and document those in the heads of terms, and perhaps think about the timing of when you might wish to approach any regulators, third parties or key stakeholders for those consents and approvals. In terms of leadership, it's really helpful to think early on about how the board of the new charity will be comprised. Will all of the trustees of both charities become trustees of the new merged charity? If not, how will it be comprised? How many from each charity are going to become trustees of the new? And what will be the process for deciding on who those individuals will be? I'm going to talk in a moment on the benefits of actually, once you've done that, operating a shadow board throughout the merger process. You should also think about the name and the brand. So what is going to be the new identity for the merged charity? And having some early discussions and reaching agreement on this can be enormously helpful, particularly for a merger of equals. You want to weigh up the need to protect and preserve any goodwill that you've generated across the two charities over the course of their existence, whilst also bearing in mind the need to rebrand so that you're reflecting this very much as a merger of two charities coming together to be greater than the sum of their parts. The other thing I would recommend, if possible, is to discuss, consider and agree what scope of due diligence you are going to carry out upon each other. Now, in a charity merger, both sets of charities will need to carry out due diligence on each other in order to enable the trustees to make a decision that is appropriate for their charity to proceed. It can be really helpful, and it provides a good level of sort of checks and balance if you agree together on a set of inquiries that you're going to carry out on each other that are proportionate and reasonable to the risk involved and the nature of the charity's operations. And if you're able to do that at the heads of term stage, whilst it won't be the full and final set of questions that you might ask during the course of due diligence, it does at least frame the initial set of questions and helps to give some assurance that you're not going to be asked as an organisation to carry out a really detailed due diligence process that might utilise more resource and cost than you are willing to incur in connection with the merger. The other thing to think about is the timetable. Have you got a proposed completion date in mind? Are there any time critical dates, any particular milestones that you both agree that you want to work to? And then finally, and these are the legally binding considerations, which you can either deal with in heads of terms or in separate agreements, binding agreements between the charities. What do you want to agree in terms of confidentiality and announcements, including things like timing for consultation with staff and stakeholders, and making sure that you keep the discussions confidential until you are comfortable to make them more public, and making sure those announcements and sharing of communications happen in the right order. You might also, depending on the nature of your operations, want to consider putting in place some binding non-solicitation/non-compete provisions, just to ensure that if the merger doesn't go ahead, you're then not in a position where, through having had sight of particularly sensitive information about the other charity, you're putting your own operations at risk. I mentioned the benefits of a shadow board. Now, particularly in a merger of equals, it's really useful if you have decided on the composition of the new merged board of trustees for the new merged charity to operate what I would call a shadow board throughout the process. Now, whilst that board wouldn't be actually engaging in any formal decision making, it does help to set the tone of collaboration and coming together and shared vision from the very beginning. It also helps with that smooth transition from operating two charities to operating one, collectively either as a group or within the same legal entity. And it can be helpful through those discussions to identify key issues that need to be properly discussed and resolved so that you can reach agreement on how you take things forward. In the due diligence process, the key thing here that I just want to highlight is the purpose. The purpose of due diligence in a charity merger is about assurance. It is about enabling the trustees to take a reasonable decision in the best interest of the charity to proceed with the merger. It's about going into a merger with your eyes open. You cannot really mitigate against all of the risks that might exist. So, you know, the staff, the position with staff, it is what it is. If you've got particular potential liabilities or concerns connected with employees or contracts or assets. You won't be able to leave those behind in a charity merger scenario. You aren't picking and choosing what you take on board. So it is about going into it with your eyes open, identifying any issues or liabilities or risks that would face that merged charity upon completion, and coming up with a plan as to how to address them. You might have showstoppers. There might be really big issues that arise that mean that your trustee simply can't proceed. And that is part of the process. It's looking for those big risks, but also it doesn't necessarily mean just because there are risks and liabilities identified that that's going to prevent the merger, but it means that you're going into it with your eyes open and knowing that you're comfortable that notwithstanding those risks, it is nevertheless in your charity's best interests. As I've said, the due diligence exercise should be proportionate to risk, and it is intended primarily to support trustee decision making. Now, a final very brief word on managing legal costs, because of course there is quite a lot of professional advice usually required in the context of collaborative working arrangements and mergers, and it's really often a very big concern is what the legal costs will be and not wanting to see those spiral. So our top tips for managing this are making sure that you instruct lawyers at an appropriate stage. Now, it can be, again, this might seem counterintuitive, but it can be helpful to get lawyers involved early on so that we can help you with some of the key legal points at the very early stages of discussions so that you don't get too far down the line heading in the wrong direction, for example, or talking about something that isn't going to work or that might be more cost effectively achieved in another way. You should also then make sure you've really progressed those commercial discussions before you start the formal legal process, making sure that you are on the same page about what you want to achieve. Being super clear about the scope of work that you want from your lawyers is really important, because the more clear you are about specifically what you want, the easier it is for your lawyers to give you a clear idea of the costs at the outset. Also, having a single point of contact for instructions and making sure that you're very savvy about how you give your instructions, not trickling things through in a piecemeal fashion, but making sure that you're collecting comments on documents, for example, and presenting them wholesale in one single communication. All of those sorts of things can really help you to contain and manage the legal costs through the process. And the other key thing is to identify key issues at the outset and discuss those with your advisors so that you can bottom out what the issue is and actually what the costs will be to address it and whether you still want to continue in the circumstances. So that's everything that I wanted to cover. And I'm just going to have a look now at whether there are any questions that have popped up that I can answer for you before we round off. So I've got a question here about timescales for a formal merger, and the question it says, I fully appreciate there are many unknowns, but an idea would be very useful. And you're quite right. Yes, it is a difficult question because there are many unknowns. Of course, it depends largely on the nature of your charity. If you've got lots of staff and you need to go through quite a lot of consultation because you're looking at cost savings and perhaps making some changes to staff terms and conditions as part of the 2P transfer. It also depends on how you structure it, whether we're talking about a change of control or an asset transfer, whether you need consent. So it is a difficult question to answer. I think I have seen charity mergers achieved in quite a short time frame, but what you should be aware of is that the more swiftly and quickly you're looking to do it, the more likely it is that costs will be higher, because there won't be the time to be quite so considered about the scope of advice that you're seeking from your lawyers. But there isn't really a sort of general rule about how long mergers should take. So I'm hesitant to give you a sort of rough idea. I think in terms of the legal steps, you would expect to, once you've got heads of terms agreed and you're sort of clear about what you're doing, you'd expect a due diligence exercise to perhaps take maybe a month to complete on financial, operational and legal. All of the legal aspects, and then you're looking at drawing up the documentation and going through those formal steps. Now that bit is more difficult to give you an idea about because it really does depend on consents and the structure and what you're looking at in terms of assets. So sorry not to be more clear about that. I've been asked another question about the use of pro bono support for memorandums of understanding and whether I'd recommend that. And I'm sure this is a difficult question to answer without sounding self-serving, because obviously we, as charity specialists, don't offer our advice on a pro bono basis. Now, I think it has its place. And if you're talking about quite a straightforward arrangement and you're speaking with somebody who is a commercial contract specialist who's willing to do it on a pro bono basis, it can be absolutely fine. The only thing I would say is, depending on the nature of the arrangement, there might be certain charity law considerations. For example, if you're doing something in the fundraising space, there's quite a lot of very specialist law and regulation on that, which you will not necessarily then get from somebody delivering the advice pro bono, because you won't get that charity law specialism from a pro bono advisor usually. I think the other thing just to bear in mind is that if you are getting advice pro bono, you're not likely to be quite so high a priority. So I think timescales and urgency of advice is something to bear in mind there as well. So I wouldn't say definitely don't ever use pro bono for that kind of advice. It really depends on risk, urgency, and the nature of the arrangement that you're putting in place. Another question I've had here is, how does a charitable trust take over or merge with a community interest company, which might then become the trading subsidiary? So I think what you're talking about there is a change of control if you're talking about having a trading subsidiary sitting under a charitable trust. Generally speaking, it is then just about taking over control. So community interest companies, just like any kind of company, will have directors and members or shareholders, depending on whether it's a community interest company that's limited by shares or limited by guarantee. But it's that top level, that membership level, that you would look to take control of. Now, charitable trusts, as you might be aware, don't have separate legal personality, and so they're not able to hold shares or membership in their own name. So that means that charitable trusts usually use a nominee to hold the shares or the membership for and on behalf of the charitable trust. So that's usually the structure that you would achieve. And again, it's quite a technical area in charitable trusts, so I would recommend that you seek some professional advice if you're not sure how to give effect to that. I think that's probably all I have time for today. Now, if I haven't answered your question and you have something particular that you want to talk about, please do pop it into the survey that you'll receive. We will get in touch and have a chat with you to see how we might be able to assist you and provide you with a fee proposal if substantive advice is needed. And thank you again for joining me today. Look out for the upcoming webinars. The next one in April will be on the new Charities Act 2022 and how this affects you. So watch out for that, and I hope to see you there. Thank you.